Welcome back to The Rose Report, a podcast where lawyers break down legal issues embedded in current events. I'm Madelaine Braggs.
I'm Olen Lenets.
And I'm Dan Gauthier. This podcast is provided for entertainment and informational purposes only, is not intended as legal advice, and does not form an attorney-client relationship.
We're back.
We're live.
We're back. We're not live, but
We're alive.
we're alive.
We're all
Yeah.
We made it.
And there's our face now.
Yeah.
We're gonna,
We putting a face to the voice.
yes.
I'm Dan, not Olen.
I know, it's confusing. I'm also not Olen. No.
I am Olen.
Okay, well, welcome back to the Rose Report. We're really excited to be rolling out a video element with this. We thought that we'd start this new year with not just a new element to this podcast with a video, but we also just kind of wanted to recap 2021. Here at the firm, we did a lot of great things. We hired 10 new people. 3 of our law clerks turned into attorneys. Congratulations to them. We had a wedding. Someone in our firm got married, and 2 more staff members got engaged, not to each other, to different people. There were 3 new babies, RLG babies. Congrats. You were one of them. You guys had one.
I did. Dan and I welcomed our son, and Dan is expecting a baby in a couple months.
Half of that statement is true.
Many co-hosts coming.
Yeah.
Congrats, you guys.
Thank you.
We'll do a baby episode soon enough.
Yeah, we'll have our babies fight. Mine's gonna win. It's gonna be like 9 months older.
On the table.
Yeah.
Right on the glass table.
I'm looking forward to that.
Gotta wait till mine can hold her head up first.
Right. Yeah.
It's only fair.
Yeah. We'll pay-per-view it. It'll be a whole thing.
Good.
Yeah.
We can make a YouTube live stream event out of it, TikTok live stream. Oh, that's another thing we did last year. We got the firm on TikTok. That was fun for me.
Yeah.
Yeah, have you guys followed it?
I don't own a TikTok.
No excuses. I don't want to hear it.
I don't know how to use TikTok. And I don't own a TikTok.
You swipe, man. You just swipe.
So in 2021, I learned how to use the video aspect to Instagram, which I did not know existed. So
What do you mean?
2022, TikTok.
Like just uploading videos? You didn't know you could do that?
I didn't know there was like a story function to Instagram. I thought it was just you post pictures.
Well, here's the other thing about Instagram.
That's new, right?
You mean this, like the 24-hour stories?
Yeah, like the Snapchat of Instagram.
Yeah, that's new.
Yeah, okay.
No, it's not.
That wasn't originally part of Instagram.
Okay, well, new
Like stories,
versus
like
was
reels.
there
No,
when
no.
Instagram launched.
Okay, in my mind, Instagram is where you put shit that you don't want to be on Facebook. You just put pictures.
Right.
Yeah.
Now,
Now people just cross-post on all 8 platforms.
I've always done that. But
Oh,
here,
really?
let me ask you this. When you post to Instagram, I've only ever taken a picture or a video that I already had in my camera roll and then uploaded it.
oh
but,
yeah.
But
No one creates.
you don't go into Instagram,
Unless
and
you're
natively take
recording
it.
your stories. That's pretty
which is
common.
what Dan's talking about.
Going in and
Can you
recording
upload
the
a story outside of Instagram?
Yeah, it goes to Facebook. You can
No,
put it goes
but
to your Facebook
Can you
stories.
record a video on your phone and then like an hour later say, I want to upload this to Instagram story?
Duh.
Why don't you stick to social media and we'll stick to law?
Okay, well, good. We're learning so much in 2022 already.
Yeah.
What about your guys' cases? Tell us some exciting things you guys did last year with your clients.
Oh gosh, I mean, more than a couple weeks ago is hard to remember.
Yeah.
Last week I closed the biggest transaction I've ever done by myself. It was a $30+ million deal.
Congrats,
Yeah,
Dan.
and it closed 2 weeks too late, but right before the end of the year. So that was fun.
I saw that email. That was good.
Yeah,
The Christmas miracle.
Christmas miracle. It took a what do they call? What's the phrase?
Hail Mary.
It takes
Takes a village.
a village.
Yeah.
Takes a Rose Law Group village. Yeah, but no, it was a busy year. It was a fun year.
Well, I
Lots
know
of successes.
the
some
firm
speed bumps.
launched the space law practice last
Mhm.
year. That was huge.
Mhm.
Yeah.
Out of this world. And
Literally.
we're going to be helping the Milo Institute Get
my
some
dog's name.
satellites up. Not the same.
Mm,
No, different institute.
okay.
Yeah. This one, arguably more exciting. No offense to your dog.
Does it piss in the house all the time?
Not the satellite.
Mm,
Nope.
yeah.
We're also going to tap into the metaverse. So that's pretty cool. Yep.
I think it's already happened. It's already underway.
We're already property
Uploaded.
owners.
That's awesome. That we're the third law firm ever only to do it?
We're the third. We are the best.
Definitely.
And I think we're the largest of the three.
Oh, for sure.
We're definitely larger than one. I'm pretty sure we're larger than the other two.
So, this firm is.
As well. Yeah, that's super exciting. That's going to be, I think Dan was saying it a couple minutes ago. That's us saying that we did this in 2021, 22 is going to be like the people who say I was purchasing Bitcoin in 2012. That's kind of where we see this going. So it's going to be pretty exciting.
And what's cool is that the difference is that in the metaverse, it's not just clients for Arizona only. It's just anyone and anything in the metaverse.
Well,
right?
there's no law. So yeah, here there's state or federal jurisdiction. There's, as far as I know, there's no jurisdiction anywhere. So the metaverse is all one big municipality, if you will.
We need to put one of those trackers out to find out when a court will for the first time try to exercise jurisdiction.
Long arm statute.
Meta. Yeah, long arm statute.
Is there going to be like a metaverse constitution?
Who knows? I mean,
if
we'll have to
we'll
write
probably draft it. Yeah.
Mm-hmm.
That's exciting. And it takes us to, our topic for today's episode. We're going to go into just some things about different areas of the law that have changed post-pandemic. Obviously, metaverse, it's a big one, and we'll probably dedicate a whole other episode to that with some experts. But until now, we'll just guess about what that'll be like. Who wants to go first?
Dan and Olen look at each other. No, I'll go.
You don't need to narrate; they can see this.
Yeah. Usually that's the part that gets cut out. But
Yeah.
now I don't think it's going to get cut out.
Usually we'd pause it, we'd argue, yell at each other for a bit, calm down. 15 minutes later, Dan would
Start from the top.
Yeah, very charmingly jump. I'd love to start.
Or no, what is it? We do sometimes in some episodes. We'll be like, "Oh, great question."
Yeah, thanks so much.
Thanks so much. That's what it is.
Yeah, our very non-pre-planned transitions.
Great question. Thank you.
Thank you for your interest.
I know this is kind of late, but we did also publish 6 episodes for the Rose Report last year. So go us. Maybe we'll have a dozen this year.
Yeah.
One a month.
That's a good goal.
Well, no promises yet, though. We're just doing our best.
I mean, it's whatever the public wants.
Yeah.
There's demand, then there will be supply. We're never too short on stuff to talk about.
Yeah, that's not true. Supply chain issues.
Olen has no shortage of professorial sweaters to wear on his.
He got dressed up for you guys. I hope you know that. He got dressed up. He's wearing.
We spray painted a wall just for today.
Yeah,
that's awesome.
The majority of this prep was doing all of this.
Don't.
It took a really long time.
Yeah.
Stop. Had the perfect angle.
Yeah. It's all billable hours though. So it's good.
I love this. All right. So, our first episode was about force majeure, is
correct
how we're saying that. And back then, I think no one outside of the legal profession even knew what that was or what that meant. And now you guys are seeing it all over, right? So,
yeah, I've had multiple clients over the last few months who we've been discussing their contracts, and they themselves have either requested it or talked about it exists and can we implement it? Does it help us? Whereas, like you said, 2 years ago, we barely knew what it was. We understood from law school that it was a concept that rarely was evoked or used, and now it's very prevalent.
For anyone just tuning in, who wants to give us kind of like the refresher on that first episode of ours on what force majeure is?
We'll go back and listen to the first
episode.
Yeah,
for anyone tuning in, go ahead and scroll down to episode 1 and hit play and join us back here in 47 minutes.
Or?
Very briefly, it's a contractual clause contingency on the event that one or both parties are unable to perform it relieves them of the duty or of the liabilities in failing to perform based on something that was out of their control but contemplated by the parties.
Right. Like a pandemic,
Correct.
which is
Now,
what happened.
No, yeah, I mean, one thing we talked about in that first episode was including a pandemic specifically within the scope of a force majeure clause. I mean, normally it would be things like natural disaster, fire, government shutdown, pandemic in a parenthetical, um, things like that, labor shortage, strike, but plus pandemic. You know, it's interesting. I think certainly in every contract I draft with a force majeure clause, I'll put pandemic in specifically now. Not only that, well, I'll actually put down a sentence or a clause that talks about government ordered shutdowns related to, because it's not just the pandemic. If you remember, it's back to 2019 and 2020, it wasn't just the pandemic that was going on. It was the pandemic plus mandatory government shutdowns. If you weren't an essential business, you couldn't be open, right? And so you not only need coverage from the pandemic, you need coverage from if you can't do what you're supposed to do because you have a legal prohibition on doing what you're supposed to do. So
one other thing I've found since that first episode that's kind of crept up is one of my clients, great client, is they're a winery and they host weddings. And I've had multiple cases where they've had bridegrooms who are trying to get out of their contract and they try to cite to the force majeure clause. But the problem is we aren't unable to or unwilling to perform as the venue. So a lot of times in the first episode we talked about using it sort of uh, offensively, and I'm also having to defend against it because it's misapplied now because it's a common word, it's a common concept, but there is a specific application for it, and it's just kind of funny. Again, 2 years ago, haven't heard of it, and now I'm using it, and I'm having it attempted to be used against me.
So in other words, the wedding venue is willing to perform and can perform, but it might just not be in a way that the bride and groom want it to be because we're in the middle of a pandemic.
Right. Or, it's been 2 years, we broke up. Well, we can still perform. That's your problem that you broke up.
Yeah, interesting. One thing that we should also mention, again, for those of our listeners that don't go listen to that first episode, is force majeure can't or shouldn't ever be allowed to get the person not performing out of paying money, right? So just because there's a pandemic going on doesn't mean you don't have to make your loan payment or your payment under a contract or whatever it is.
Right.
But that's key that we've also had to defend against if someone's refusing to make a payment based on pandemic.
Right.
Right.
I mean, that seems to kind of be, even without any legalese, it's just, well, there's a pandemic, so I'm excused.
Yeah, it's like the throw your hands up in the air kind of thing, pandemic, right?
Right. Yeah.
Use it as an excuse.
Yeah.
So
how was it like for you guys this past year and, really 2020 when it hit harder, transitioning to like Zoom court and like Zoom counsel? What was that like?
Amazing.
Yeah.
I mean, have you been downtown to the court? The majority of Maricopa Superior is downtown on Jefferson. And so parking's a hassle. You got to get in the garage, walk 7 flights. So if I have a hearing at 2 o'clock, being in Old Town, I leave at 12:30, maybe 1, and I don't get back to the office until, even if it's a 15-minute return hearing, let's say, I don't get back to the office till 3:30. Now it's hearing at 2, great. Throw my tie on at 1:58, do my hearing, throw my tie off, and go back to work. So,
now that things are opening back up and kind of returning to some sense of normalcy, even with like mask mandates, are you guys finding that Zoom court is still like an option, or are they kind of starting to stray back into bringing you back?
I love it. I think everyone likes it. I will say that the one drawback that I've noticed is a lot of times hearings aren't even on video. It's just telephonic, which is an option. It's common, but pre-pandemic it was, but certainly not almost everyone. So I have noticed there's a bit of a crutch where if you're going to be only on audio, you can have your notes up. You can essentially write your argument out and just read from your pad which you could do in open court too. There's mixed feelings on how to do that. Some people think that the presentation suffers from that, and it hurts even if you have a good argument. If you're just standing there, it's like giving a book report, right? You're just
Yeah.
standing there reading with your face in your pad, and even if what you're saying is great and perfect and right, it's not going to have that same effect as if you're making eye contact with the judge and delivering a performance, essentially, which is what you're doing. So I have noticed there that it's a bit of a crutch knowing it's going to be telephonic. I don't not prepare as much, but in fact, I almost over prepare in the sense that I write out more than I would just notes on my pad to like, I want to hit this point and this point. I will make my full argument. I've caught myself doing full case citations because it's sitting right in front of me rather than just saying, the main case name or stuff like that. So I am excited in that sense to go back to in person because I think you prepare differently. And I think I've gotten really good at preparing in the kind of comfort of hiding behind just the phone or the microphone or whatever. But it's more of a trial type of setting where you're actually performing, making eye contact, making more of a show, and I think that's a good uh, talent to have as well.
Right on.
And luckily, I don't go to court, so I don't deal with that, and have never. But what I will say is over the last, it hasn't been all of 2020, but in 2021, but maybe like year or so, I've started to do in my transactions. I've started to do Zoom calls or Teams calls or whatever the technology is that we use on that for that given client, to have like a group call with the other side's attorney and sometimes the principals, the clients on as well. And we'll quite literally pull up whatever document it is that we're working on and we will go through it together because that has been the most efficient and most reasonable way to go through a document. You find that it's a lot harder for an opposing lawyer to make 60, 70, 80 comments on a document when they have to do it live in front of you instead of, like you said, behind your computer and
Right.
typing away, right?
And answer to it if you say, well, why do you want that?
Well, and that's the beauty of it, right? Is because every single change you say, why do you need that?
Mm-hmm.
And then they have to explain it, and you don't even have to do anything beyond that because if they can't explain it, they'll just say, I guess we don't need that, right?
Right. Yeah.
So it's been great.
Yeah. Another fun thing about hearings, for example, in my office, I have 2 monitors on a swivel. So Dan and I have a few cases that are in litigation, and he'll come in and sit in my chair across from me. I'll turn one of the monitors and mirror my monitors so I can see, and the camera's on me, but he's sitting basically watching everything. And like we'll kind of like sneak glances at each other and like make faces when we're off camera. When the other side's making an argument that we think is bad or something like that.
I bring pom poms.
Yeah, just working behind for me. So again, that's not something that would ever happen in open court. We wouldn't be like high fiving and winking at each other during someone else's presentation. But again, that's just a fun little aspect that the pandemic has allowed us to have.
And hopefully for you guys going forward, hopefully you guys can keep the camaraderie.
I mean, yes, that for sure. But I do think that there has been a kind of a paradigm shift in the way the legal community views hearings. And I think mediations, especially, they have been very successful with Zoom. Early on, it was, a catastrophe sometimes, especially if the mediator wasn't very technologically savvy.
Like cat lawyer.
Yeah, like him. Yeah, you'd have multiple phone calls where like, okay, get in, like log off now, get back on now.
Yeah.
And then I had one maybe a month ago, and this guy was great, and he had breakout rooms on Zoom, and he would pop in, he would pull people in if you needed to talk to someone else. We had 3 different parties mediating, super efficient, and I don't think it would have gotten done in the same day. It took all day. We got it done at like 5 o'clock. But had it been in person and he's even walking room to room, that's 10 seconds each time, and he had to do that 25 times. You're already adding so much time to that. So I think there has been an understanding in the community that maybe using technology, if used properly, is better than doing everything in person. And I know some people old fashioned and difficult to, hard to change. But I think generally that's been the trend, and I like it.
I definitely like that hybrid option,
Yeah.
but like we've said before, here at the firm, I'm the chief digital officer, and so I don't really have to access the same kind of like servers for programs and documents, so I can kind of do that anywhere, and it's been
Yeah.
working out for us over in social.
I mean, I feel like you would want everything to keep getting more digital
I definitely do.
and yeah, more adaptive with technology because that only makes your job more fun
Yes.
and
Like this right
yeah,
now
right.
with you
Yeah.
guys. How cool. Excellent. So, Dan, I know you were mentioning there's been a change with notaries also.
There has been a change with notaries. We have online services now for, notaries would normally be in person looking at your driver's license, obviously recording it in their notary book and signing. Um, this is a state by state answer as well. So, if you're not in Arizona, certainly go look. But in the state of Arizona, online notaries are more prevalent. I'd say less commonly used today in my practice than they were in like mid 2020, but it's caused a whole new industry to pop up, right? And it's one of those things that, why not? Why not do something that's more convenient? And
So, how, besides it just being like online, what are some characteristics about the difference of, being able to have that new industry and service be online? Like,
well, I mean, it's quicker for the person needing a document notarized for sure, right? So if you were to just log into a system and pay, a nominal fee to have someone pop on your webcam for a second and verify who you are and watch the signature being written out, then you're saving the time of getting in the car and driving to a bank and waiting in line, and that's the traditional way. We have some clients here that obviously just come in and get it notarized in person, but
because we have people who are notaries here in the firm, so it's
absolutely,
usually
as
on
does
site.
every law firm, I would imagine. But if you're not working with a lawyer, right, and you just need a document notarized, I know I've done it a dozen times. Go to a bank and sit in line and wait, and so you can avoid that. Why not? That's my view on it.
Fantastic.
Yeah.
Fantastic.
You want to talk about non-competes?
Yeah, let's do that. So this came up because one of the attorneys had come up to me one day and asked about TikTok. And I guess he was curious as to how do non-competes need to change for entrepreneurs and businesses that are online based, where all of their clients are acquired through marketing online on TikTok specifically. So I'm obviously not a lawyer. I had to go and pitch that to Logan Elia, who's been on the podcast before, and he does a lot of our cyber law.
Friend of the show.
Friend of the show, yeah.
I think it's friend of the pod. Is
Friend of the
the friend
pod.
of the
No,
pod?
I don't know. I like that. It's
No?
friend of the show,
Friend
yeah.
of the show.
Yeah, partner and friend of the show. Yeah.
Yeah. Okay. Anyway. So yeah, they went and they started strategizing about that, and what they were kind of getting down to now. Olin, I know you have some thoughts about this, but what they had suggested is to where usually non-competes are have the factor of geographic location and similar industries, but how do you really enforce that when your business is based on TikTok? It's not really just about geographic location anymore. How do you get someone to not go and market on TikTok with another company? And they're saying perhaps by language, saying, well, you can't go work for any other TikTok marketing company that speaks English. How about that? Or Spanish, if that was relevant. What do you think about that?
Would it be helpful to describe like the general limitations on non-competes?
Yeah, go ahead and do that because I feel like that kind of answers the question in and of itself. I mean, Madelaine, sorry, touched on it by saying there's a geographic element to it, and I feel like one of the main things the court will look at, and I know, is the scope of that. And by saying language, you are blowing that scope out of proportion. because it's not just a geographical location, it's literally the entire world could be covered by this. Because I don't know that unless the requirement would be to you can't market essentially to someone that lives in a predominantly English speaking country, or if it's literally anyone who knows how to speak English, or like it that just sounds completely unenforceable to me. I will say though, the way it was initially presented, I thought you were talking about the actual uh, person using TikTok, not a business using it as a tool. But I think that doesn't change the
So
analysis at all.
let's set the stage a little bit, right? So with a non-compete, you, at least in Arizona and in every other state I've ever looked at, this is a form of restrictive covenant, right? So it's a um, restricting your rights to be able to work or to be able to seek other employment or hire certain people, so on and so forth. So courts will look at these and that they don't like them, right? They have this standard bias
Right.
against non-competes.
Favor free market, favor people
Exactly.
contracting, doing what they want to do, as long as it's a mutual agreement between the other parties.
Right. So in Arizona, there's two, and again, likely across the country, but I know in Arizona, there's two primary characteristics to a non-compete. So you have the duration, and you have the geography, and then a third would be the actual scope of the what it is that you're restricting, whether it's an industry or a specific type of business, and so on. So geography is usually tied to, I don't know, what would you say, like a county,
If
either
that,
a
like
county, a
miles.
city, a number of miles.
Yeah.
The example I like to use is I have a client who's a veterinarian, and the veterinarian is restricting his doctors, the other vets, from quitting and going and opening another vet within 5 miles or 10 miles or whatever, a small number of miles from that location. And the idea is, we're reasonably preventing other vets from popping up and taking away business from the existing. Sure. Yeah. So we've got geography and then we've got duration. And this is state by state as well. Arizona looks at what's reasonable, the minimum amount of time that's reasonable to protect the employer. So in Arizona, it's fairly well understood that as long as your facts support it, 6 months or so is a reasonable amount of time. 1 year sometimes, and then once you get over a year, it sort of goes all out the window. If you have the facts to support it, there's been some cases that enforce them up to 2 years, even longer, and some cases that say no, even a year is not enforceable. So it totally just depends on the facts. And so here we're saying, okay, we've got an online business, an e-commerce business, and we're selling goods across the country. And maybe we have remote workers that work all across the state. How do we restrict them, or from where do we restrict them from being able to work? Is it a couple of miles from their home? Is it from our business location? Is it from our manufacturing facility? Or is it across the country, right? Maybe they don't even, like in your example, Madelaine, maybe they don't even produce a product. Maybe it's the product is themselves. Maybe it's TikTok, right? And they have employees. So um, I know that when I looked into the question, I talked with another one of our lawyers that was actually looking at this for a client. He did say, and I don't have citations, but I'm sure, get them from him. Arizona hasn't ruled on this, but other states have said that if you sufficiently limit the duration, so like 6 months, 2 months, 3 months, under 6 months, probably for sure, then you can broaden the geography. And so if your facts support that, maybe you can go, I don't want to say nationwide because that sounds like a scary thing to say when you're talking about non-competes, but maybe a 60-day or a 90-day restriction on a nationwide business competition could be enforceable. It's really interesting. I think courts are going to have to answer that question though, because it's inevitable.
What would you guess if the case were, what did you say earlier? Let's set the stage. I like that.
It's, it's,
Yeah, let's set the
yeah.
stage. What if it wasn't necessarily like TikTok marketing? What if it was like somebody had set up an Etsy shop and making soaps and they had an employee to help them make the soaps and then they wanted them to sign a non-compete? what would it also kind of be nationwide? Like you can't work for any other company making soaps?
So think about it this way.
I don't think that would even occur.
Well,
Why
but
not?
it depends on how good this person is at making soaps and how, because think about the facts, right? So like you've got this soap maker,
Mhm.
maybe they're the best soap maker in the world, and maybe they did an apprenticeship for 6 months on how to learn how to make soap, right? And so the business is saying, I spent a bunch of time and money training this person up how to be the best soap maker in the world, and if they leave, it's going to take 6 months to find a replacement. Like if you could support that, I mean, those are the types of facts that you'd have in order to make something like that work. But in theory, if it's just me making soap in my kitchen, right, and you could hire Olin to make the soap instead of me, I don't think that I could restrict, or I don't think that the business could restrict me from going somewhere else and making soap elsewhere. Does that make sense?
Yeah.
In some sense.
Yeah.
I guess we should ask our listeners.
So do you think that this new digital era and gray area for non-competes, do you think that that hurts entrepreneurs more or like employ the labor force more? Who's really going to be the most affected by these changes?
I think that as long as the courts follow in a reasonable amount of time, then employers will benefit from this because right now, I don't know how many non-competes you look at, Olin, and just on their face are just completely invalid, right? And would it be
I've seen a few.
50% or more of the total?
Yeah, more, yeah.
More than 50%.
Yeah.
So I think that
But it's one of those like shoot for the moon situations.
Right.
And more likely than not, it's just going to be a deterrent. Or by the time you finally litigate it, you've gotten 8 months of restraint on the person, and then what's the other 4 months that they've gotten out of at this point, right?
Not legal advice, but just a key point, right? When you're looking at non-competes, this is an important thing to look at. It's a good point. Is some non-competes, not all, will have language in there that says if the employer thinks that the employee is breaching the non-compete, then whatever duration it is, if it's 6 months that the non-compete runs, gets suspended in time until it's determined whether or not
Right.
there is a violation. So in some cases, your 6 months wouldn't run out, but in some, it certainly would, just to litigate or fight about the dispute. But anyway, I think some are unenforceable. Many are unenforceable now that we see, and we have to sort of walk them back for our clients, or help our clients get out of unenforceable ones.
Right.
So maybe this will make more enforceable because you're going to be limiting duration, which is often the kicker, because people just say, you can't make soap for 5 years, right? Period. And a court's never going to enforce that.
Okay.
The world needs good soap.
The world needs good soap.
I don't know it.
I think another interesting thing with technology, TikTok, you mentioned specifically, or just influencer type stuff, that is so entrepreneurial and kind of individualized that I don't know if scaling is even possible for most of those kind of brands or businesses, whatever you want to call them.
Right.
And that's where the non-compete, the non-solicits come into play. It's you've scaled so much that you don't want a mass exodus of employees or talent because then you are going to be adversely affected by a competitor. Whereas in the TikTok world, let's say, that market is entirely oversaturated because anybody can be in that market. There's absolutely no requirement except for some, genuine creativity or talent. But I think what we're finding out is that that's pretty widespread. Also, there's not like a specific niche for this. There is very specific niches for things, and so your success on a social media platform could be completely different than Dan's, and there would be no overlap in your viewers or your followers or whatever, and you could get as huge as you can imagine and still be a solo operation, or certainly not to the point where you'd be getting employees. Maybe you'd be getting a contractor or two, and that's even harder to restrict through a non-compete or a non-solicit than an employee.
So in this influencer example, can other brands try and enforce non-competes with these people who are promoting their product? Like, for example, if Nike approaches an influencer, can they make them sign something that says you can no longer, like now you can't promote Coke products?
Yeah,
Okay.
Yeah, and
absolutely.
it's inexclusive, right?
Yeah.
So you can only promote our products,
Yeah.
or you can promote ours and others, but not certain other products.
Okay.
It's like we've negotiated some contracts for I won't call them influencers, but
I was gonna say, you guys
fitness
have any influencer clients?
fitness entrepreneurs like trainers
Yeah.
but ones with a social media presence.
Right.
So those contracts will contain things like you can't post pictures of yourself getting blasted on the internet, right? Or you can't post a picture of yourself with a cigarette in your hand
Mhm.
because that's going to tarnish the brand that you're working for. So like restrictions like that have existed for a long time.
Okay. I'm hearing a lot of like space related words like blasted and it's like a shoot for the moon scenario. Is this because of space law?
We're
Yeah, we're
just
plugging
passively
space law,
plugging
right?
our space law
Yeah, okay,
program
good.
here.
Just I didn't I felt like it was too subtle. I wanted to make sure everyone knew and heard that.
Yeah,
Okay,
no,
good.
we're
More
just,
exciting things to come on our space law practice.
yeah.
Yeah.
We wanted the listener to tune off of this and be like, very, yeah, like
Space is like in the back of my mind.
final frontier.
Yeah.
Yeah.
Not Alaska.
But now we've kind of shown our cards here.
I can cut it.
Yeah.
Okay. Anyway, what else? What else is different now? How about COVID disclosures and like real estate transactions? You see a lot of that?
Yeah, good question. um,
Good freestyle off the cuff.
yeah, yeah. Everyone in the real estate industry, for our listeners that are in it, know this is very busy or has been at least toward the end of 2021. Um, and add on top of that um, a pandemic. And again, this wasn't as applicable toward the end of 2021, but earlier in the year and certainly in 2020, we had governmental shutdowns. And so if a title company or an escrow agent had to be closed, um, what if a transaction can't close, right? And so we've started seeing disclosures in purchase and sale contracts and in other transactions that have an escrow component because if the transaction can't close as a result of a restriction that is outside of the buyer and seller or whatever two principles there are, um, neither side wants to be at fault for that, right? So we've started to see that. The issue is that that could be taken advantage of, right? So if I'm a buyer and I want more time on the transaction and I've got a disclaimer in there that says if the title company can't close as a result or for a reason related to pandemic, maybe I as the buyer won't turn in my closing documents until the last possible second and blame it on like we said earlier, raise your hands and blame the pandemic. So I think it can be abused, but we've certainly started seeing more of that.
We're onto you, abusers. We're onto it. Dan's seeing it.
I'm talking about abuse on the fly. I would never engage in that.
No, I know. I know. Okay, Dan is not abusing COVID disclosures.
I'm not.
No,
No.
others are.
No.
You won't say.
I won't say.
Okay, good.
Not my clients.
Tune in next week to find out.
Good. That was a trust test you passed.
Yeah. Trustful.
Yeah. What else? You guys have any really fun cases that stood out to you in litigation?
Um, kind of. We wrapped up a bunch of not super interesting or wild cases, but just ones that have been around for a while. So that was just nice to find all of them successfully or with settlements or final judgments in favor of our client. So that was really great. I did have a case like 2 months ago that was very unique, and the details of it are irrelevant, very boring. In fact, speaking of non-competes, it had to do with that. But what was interesting about this case is that it was a non-compete from former employees of our client, but they had forgotten that they had left all of their devices logged into our client's work product. And so one of the things they left logged in was their text messaging app. And so for weeks, while we were writing demand letters and negotiating and ultimately settling and resolving this whole thing, we have a live stream of every single message that these people are sending between each other and anyone else. So not only are we getting documentation of what they're doing on the weekend or whatever, but their real-time strategy on how they're trying to take advantage of our client and win the case essentially. Thankfully, we never had to file suit and we got it resolved. But it was weird because it was almost like you had a cheat code activated, but knowing the stupid thing they were going to do, I realized didn't help me. Like knowing it or anticipating it, I still had to kind of overcome it in the same way. And I expected to kind of, being one, two, whatever you want to say, 5 steps ahead would have been an advantage. But I found myself doing the exact same thing I would have done had I not known an hour before I got the email saying what it's going to say, that it was going to come. Like that time didn't really help. So I don't know what my takeaway from that really was. It was
It's
just
log out of your devices when you trade them in.
Right. I mean, more professionally, what my takeaway is, because again, that's like everyone's
Are you
dream is
sure?
to know your
Was it
opponent's next
helpful?
move. But it wasn't. I mean,
Why?
and again, maybe it's because what all the moves they were making were so bad that it just it didn't make sense for me to have to anticipate any of it. But it was just funny again, like knowing I'm going to get a phone call at noon because we have a noon call scheduled, and then knowing at 9:30 that we're going to say this and this and he's going to say this, and then if he says this, let's say this, and then just like having the script in front of me and like saying it and then like knowing what the response is going to be. So that was just very unique. I can't imagine something like that will ever happen again. That was kind of fun.
Sick. That's awesome.
Did they ever find out?
No.
Never found out.
Well,
We were
might.
close to
Didn't need to tell them, right?
yeah, we were close to needing to leverage that because they kept trying to make the deal to resolve all this and then breaking it. So we were very close to needing to say, by the way, if you're going to force our hand here, we have everything. But thankfully we didn't have to, and we got it done for the client. Haven't heard. And it's been a month now. Haven't heard anything.
Been tracking the text messages ever since.
What do you think would have been the blowback or the response had you had to employ that?
It would have been terrible for them because, I mean, they outlined their plan that they denied was their plan. And so if we had to file suit, they would have filed an answer saying deny. And then I would have said, okay, but here's proof.
Mm-hmm.
And then it's really hard to get out of a denial when I have the text message confirming it that you sent to your co-conspirator.
You think they would like?
And there were like personal things. I'm glad I didn't have to go there because there was personal stuff that would have gotten entangled and like not my world, not my place, but like it was something it would have been something I would have had to deal with, and it just would have gotten sticky.
Messy.
And yeah, and I'm glad I didn't have to.
You think they would have like tried to countersue and say that you guys were like not cyber stalking, but what I don't know, voyeurism, something? You bugged
No.
the room? No,
I mean,
you can't?
I'm going to sue you for taking advantage of my stupid decision.
Yeah, I mean,
I feel like they wouldn't have been the first to try it based on that, right?
Yeah. Invasion of privacy.
I mean, we did look into it, thinking, but I mean, this is a work device
Mhm.
that was voluntary. It wasn't like a requirement by the employer that you have to have your personal stuff
Mhm.
connected to this. They chose to do this. They chose to leave it on. And I mean, frankly, the funny thing is, had this gone to litigation, it would have all been discoverable and subject to disclosure. Now, I bet you when I asked for it, it would have gotten deleted and disappeared and they would have no longer had it.
Mhm.
So I wouldn't have gotten it. But nothing that we were seeing is something that if the proceeding plays out as it's supposed to, we wouldn't have seen. We were just seeing it months ahead of time.
Mhm. Wow.
Like
Hilarious.
I guess to give a very simplified example, you're playing poker, Dan's holding 5 cards. I'm gonna see what those cards are. If he goes,
Right.
and wants to make the final bet, I knew ahead of before the cards were even shuffled what his
Right.
cards were going to be because he had outlined. Well, I guess it's a bad example because you don't know. But
As soon as I
Yeah.
look, as soon as
as soon as Dan looked at
I'm
the
there with
cards,
you.
yeah,
I'm there with you.
I'm a big poker player, as you can tell.
Yeah, same. You got a great poker face, right? Yes.
Yes,
Yes. Good.
that was me bluffing.
Well, gentlemen, it's been a wild ride. 2021, kind of 2022 gets lumped into. They're like kind of one year, right? I don't know. I feel like they get lumped in together.
I guess we'll find out.
You guys
2020
looking
or
forward
2022?
Oh, you meant 2020 and 2021? Oh, I thought you meant
Yeah, I feel like
2022.
March of 2020 to today is just
One
been
year.
1 year. Yeah,
Exactly.
yeah,
I think March of 2020 until COVID is done is going to feel like
Right.
1 year.
yeah,
Or a lifetime, depending on how you think of it.
yeah.
These will be the stories that we tell our grandkids. Just keep thinking about that, right?
Are you guys looking forward to anything this year?
Dan's got a baby on the way. I'm really looking forward to that.
Me too.
Me too.
I meant professionally. Any cases you guys got fresh this year you excited for?
Um,
I'm sure they'll come eventually.
I mean, Dan and I have had 2 cases for one for almost 2 years and one for a year, and at least one of them will get resolved this year, I think. And I'm excited mostly for the client for finality on that. So that'll be good. Um, yeah, I feel like there's kind of a handful of cases that I've had for some time now that are finally reaching that dispositive motion, trial, settlement conference type stuff where it's going to get resolution. And all of them I feel really good about. So
Well, that's
I'm excited
exciting.
for that. Yeah.
I'm excited for you.
Yeah. And
Excited
maybe
for
we'll
you
be
too.
back in live court at some point this year, which will be fun too because I haven't been inside a courtroom. I think I had a few during the pandemic. Like probate court was still doing live and bankruptcy court. I had an overlapping case that I had to go to bankruptcy court. So that was still happening. But I haven't been to superior court since 2019. So it might be nice to step back in the courtroom.
Well, you guys, we are so looking forward to many more podcast episodes for you guys. As always, feel free to send us your ideas at Rose Law Group on every platform.